Hello, everyone. I'd like to welcome everyone to our discussion today on trucking risk management for motor carriers who utilize independent contract drivers. My name is Peter Gillette. I'm from Kingfish Insurance, and I'll be your host. And I have welcomed today to join us in the discussion James Caulfield, the president of Oracle Consulting Group, a national transportation financial risk management firm. Hi, James. Welcome to the program.
Thank you, Pete. Thank you for the invite.
Let me start off by asking you, why are motor carriers finding it increasingly difficult to protect themselves from independent contract drivers who seek employee reclassification to obtain work comp benefits?
Well, motor carriers increase their financial, insurance, legal, and tax liability exposures through the issue of 1099s to their owner-operators and independent contract drivers. If the motor carrier thinks they're properly protected by extending a workers' compensation benefits through a company-sponsored program or providing occupational accident contingent liability coverage to their owner-operator fleet, they're not. Their protection level is comparable to a terrorist hiding out in a so-called safe house in Abbottabad, Pakistan, knowing that Uncle Sam has dispatched SEAL Team 6 to their location. Presently, the Internal Revenue Service has been cooperating with state agencies to fight the misclassification of independent contractors, as well as entering into information sharing agreements with 30 states, and that number is quickly increasing. Not to mention the fact that now the federal government has allocated $25 million to the Department of Labor and the Treasury Department to specifically target employers that are misclassifying workers as independent contractors.
What creative risk management transfer solutions exist for mitigating these owner-operator reclassification challenges?
The motor carrier really needs to erect what we like to call firewalls, and that allows for a stronger defensive position in defending the independent contractor status, as well as protecting balance sheet assets from seizure. Now, this can be accomplished in several ways depending on the motor carrier's current program, the states the drivers operate in, and the level of protection desired. Firewalls are created through various risk transfer arrangements in addition to the motor carrier's existing owner-operator agreement, along with the elimination of the contingent liability coverage as a reimbursement tool, and utilize the if any workers' compensation policy as a proactive frontline defense to stop all reclassification actions. This creative risk transfer solution severely limits workers' compensation claims from being paid by the motor carrier's workers' compensation provider, which in most cases will trigger an audit of all the 1099 compensation paid to the drivers currently and the previous 3 years, and which is understandable due to the fact that the carrier has now paying claims on drivers they never received a premium for. And also allowing workers' compensation claims to migrate back to the corporate work comp policy may also create an opportunity for all the 1099 drivers to seek employee status and more than just workers' compensation benefits.
What solution would you suggest for the motor carrier whose only protection from employee reclassification actions is through the purchase of occupational accident and contingent liability insurance?
Well, I think there's a very big misunderstanding in the marketplace concerning contingent liability and what it is. Contingent liability cannot pay statutory workers' compensation benefits. It cannot defend the motor carrier before a workers' compensation board. Normally, on a declaration page of a contingent liability policy, you will find terminology such as, this policy is not a workers' compensation policy and is not a substitute for workers' compensation coverage. Contingent liability should be viewed as a passive reimbursement tool and not a defensive mechanism to protect the motor carrier's corporate work comp policy. There's actually two creative risk transfer solutions for the motor carrier to consider depending on the level of protection desired and if the motor carrier would like to outsource the driver's settlements to a third-party contract administrator who would process the driver's settlement under their federal tax ID number instead of the motor carrier's. One risk transfer solution that would mirror which most carriers have currently who are using occupational accident contingent liability and processing the driver's settlements in-house would be a risk transfer solution number one, which is referred to as the standalone program. Now, this standalone program would allow the motor carrier to continue to process the driver's settlements in-house as they're currently doing, but this program would eliminate the contingent liability coverage and add the if any workers' compensation policy for approximately $26 per month per driver, excluding North Carolina. And the motor carrier would be the named insured under the alternate employer endorsement. This program allows the motor carrier to be provided with a workers' compensation certificate of insurance for each driver to retain on-site for their records. In addition, both programs provide the drivers access to a benefit platform with a cafeteria style of health and retirement programs.
Is there a more complete creative risk transfer solution available to motor carriers?
There is a second risk transfer solution which utilizes the services of a third-party contract administrator who processes the driver's settlements underneath their federal tax ID number, and the driver's premiums are then deducted from their settlements. This eliminates all premiums that are currently being paid by the motor carrier and settlement deducted in-house under their federal ID number. This also creates an additional line of defense in the protection of the independent contractor status. The third-party contract administrator has another layer of workers' compensation protection via their corporate work comp policy, which names the motor carrier as a certificate holder.
Would your solution be applicable to motor carriers who purchase workers' compensation for their independent contract drivers and back charge the premiums?
Yes. Workman's compensation, for all intents and purposes, is an employee benefit. So when a motor carrier purchases a workers' compensation policy for the independent contractors and back charges the premium, they dilute their position of defending the independent contractor status and are limited in their defensive position by only their owner-operator agreement, which is subject to interpretation along with the direction and control issues. If the motor carrier is providing workers' compensation to, and the independent contractors then file an unemployment claim, the motor carrier will have to substantiate why they're providing an employee benefit for the drivers on one hand, but don't feel they're entitled to provide an employee benefit on the other hand. Not to mention the fact that the motor carrier has a huge target for reclassification called 1099 compensation. It's recently, as of July 15th, 2011, there was a lawsuit filed against Ironbound Express in New Jersey Superior Court. Now it's pending in the federal court, and it's a perfect example of why not to purchase workers' compensation for independent contractors and back charge the premiums to the drivers.
Is there any other creative risk transfer solution a motor carrier can take to protect themselves for disastrous financial loss?
Well, the only one that I'm aware of, and insurance agents and brokers don't want to hear this, but it would be the errors and omissions policy that their current agent or broker has. If he's not provided these additional options and shown a motor carrier how to bring in some additional contracts into their independent contractor relationship, is not showing a way to outsource their 1099 settlements and get that off the books, then I think the agent has really put himself in a very poor position if he just sticks with the standard status quo what the industry currently has.
Thanks so much, James, for helping shed some insight into all these issues. And if anybody has questions, if you can reach us directly at Kingfish Insurance. That number is 888-339-2815.